Finally, to revert from these practical lessons learned to our general theme, there is yet another dimension, sometimes referred to as the normative effectiveness of environmental treaty making. It has been pointed out that a major challenge for any international regulatory regime is its legitimacy, in terms of its actual acceptance by those to whom it applies, be they states or individuals. In a legal sociological perspective, legitimacy is usually seen as a matter of due process. It refers in particular to the transparency and fairness of decision-making, including public participation and equality of treatment in the way a treaty is implemented. In this regard, the track record of most environmental agreements has been exemplified by procedural instruments such as the 1998 UNECE Aarhus Convention. At the same time, however, the complex standard of legitimacy, so injected in the evaluation, also implies conformity with certain substantive values and normative expectations that must be shared and seen to be shared by the community of contracting parties to keep the agreement effective over time. Take a second look at the table of trade sanctions imposed on the Endangered Species Convention CITES for inadequate national legislation from 1992 to date, which we discussed before. It reveals a rather perplexing north-south imbalance. No less than 92% of the states targeted by CITES trade embargoes were developing countries. And the last time a developed country, Greece, was sanctioned was 17 years ago. Even though inadequate implementation of the convention is undoubtedly often caused by a lack of administrative and financial capacities in the third world, to find sanctionable compliance deficits almost exclusively in the South comes as something of an empirical surprise. Critics have not hesitated to attribute these findings to a hidden neo-colonial bias of the regime. Past infraction reports by the CITES Secretariat and by NGO observer groups certainly indicate that infringements of treaty rules and conference resolutions are in no way the sole prerogative of wildlife exporting countries, so there must be other explanations for the skewed geographical distribution of trade embargoes as currently practiced. To illustrate my point, let me conclude with a recent case that is well documented and anything but trivial. Between 2001 and 2016, the Japanese Institute of Cetacean Research, ICR, caught a total of 1,369 sei whales from areas outside Japanese territorial jurisdiction in the North Pacific as part of the government's so-called Research Plan for Cetacean Studies in the Western North Pacific under special permit, JARPAN-2 is the acronym. Yet, the North Pacific population of sei whales, Balaenoptera borealis in CITES Latin, has been listed as strictly protected under Appendix 1 of CITES ever since the entry into force of the convention in 1976. Although Japan had entered a reservation against the Appendix 1 listing of the entire species in 1981, that reservation explicitly does not apply to the North Pacific population, which therefore remains categorically excluded from international trade or introduction from the sea. Consequently, the Japanese catch and introduction of North Pacific sei whales raises a question of persistent non-compliance and possible action under CITES Article 13 and Conference Resolution 14.3, the compliance procedures, for several reasons. First, to this day, I show you the reservation. The Japanese government has not designated an independent national scientific authority under Article 9, qualified to issue non-detriment findings for introduction from the sea under Article 3. Conference Resolution 10.3 expressly requires scientific authorities to be, I quote, independent of management authorities. Yet, the Resources and Environment Research Division in Tokyo, which the government notified to the CITES Secretariat as its national scientific authority for cetaceans, is a mere administrative subdivision under orders from the Japanese Fisheries Agency, which serves as a designated management authority for whales, and in that capacity issues all the permits. The country, therefore, has for years been in manifest non-compliance with one of the elementary treaty obligations listed as a potential basis for trade sanctions. Secondly, the special permits issued since 2001 by the JFA for the taking of North Pacific sei whales, this is the permit for 2016, for this year, may meet the requirements of the controversial loophole clause of Article 8 of the International Whaling Convention, but they do not meet the stricter stipulations of CITES Article 3.5 for introduction from the sea of specimens of a species listed in Appendix 1. Those provisions require, in addition to the mandatory independent scientific non-detriment certificate, which I mentioned before, a specific finding by the competent management authority that, I quote, the specimen is not to be used for primarily commercial purposes. Conference Resolution 5.10 then goes on to define that requirement as follows. Again, I quote, all uses whose non-commercial aspects do not clearly predominate shall be considered to be primarily commercial in nature, with the result that the import of specimens of Appendix 1 species should not be permitted. End of quote. In view of the notorious factory practice of the ICA, this is a factory ship processing a sei whale, which only extracts less than 1% of a whale's biomass for subsequent scientific analysis, biopsy and stomach content samples, while the economically usable rest of the catch is processed on board as byproducts for subsequent marketing, that definition would seem to leave hardly any room for discretionary interpretation. But be that as it may, part of the political empirical reality also is the fact that Japan has not only been a member of the CITES Standing Committee, chaired by Norway, for the past 10 years, but remains the second largest contributor, after the United States, to the Convention's budget. For diplomatic reasons, other member states will inevitably think twice before antagonizing such a heavyweight member country by allegations of non-compliance, let alone initiating adversarial legal proceedings. Future recourse to the International Court of Justice is precluded anyway, following Japan's recent amendment of its acceptance of the court's compulsory jurisdiction on 6 October 2015 in the wake of the Antarctic whaling judgment, which now expressly excludes, I quote, any dispute arising out of, concerning, or relating to research on or conservation, management, or exploitation of living resources of the sea, unquote. When the UK CITES Management Authority in 2007 for the first time had the audacity to draw the attention of the Secretariat in Geneva to possible Japanese treaty infractions with regard to trade in whale meat of Appendix 1 specimens, and to suggest non-compliance proceedings under Article 13, the Secretariat's mild response was that the granting of special permits for research whaling under Article 3.5 was entirely within the discretion of the National Management Authority concerned. Whereupon the legal advisor of the ICR, the Institute for Cetacean Research, who happened to have been a member of the Japanese delegation to the CITES Standing Committee, promptly declared both the Antarctic and the North Pacific whaling programs compatible with the Convention, citing the Secretariat's opinion in support. All further appeals to the Secretariat for action regarding North Pacific sei whale catches in subsequent years, also after the 2014 ICJ judgment, were unsuccessful. The legitimacy of an international nature conservation regime is crucially dependent on trust. Trust that rules will be applied equally to all participants in the system on a common basis of transparency and accountability. CITES, and its unique compliance procedure in particular, is widely respected for its effectiveness in protecting endangered species against the threats of illegal trade and overexploitation. Yet, when an otherwise successful treaty regime begins to apply, for subtle diplomatic reasons, double standards in favor of prominent member states, the regime as a whole could well risk losing part of its credibility and hence its sociological balance and legal certitude. That's where I want to end.